I think they landed a few blows and perhaps showed some inconsistencies. They also brought out something which had been brought out on direct examination, that Cohen had stolen money from Trump. But all that simply goes to the issue of the ultimate issue of credibility, which is for the jury. And on cross-examination, defense lawyers often score some points. The witness, Cohen, is now on redirect. Susan Hoffinger is a terrific prosecutor. And I assume she's going to bring out through questioning Cohen's clarifying testimony about the famous telephone conversation that he claims he had with Trump when the text messages show that they were discussing some other subject. There were many other telephone conversations, the October 26th conversations notably, that Cohen had with Trump. And the basic point is that Trump approved of the payment to Stormy Daniels and approved of it being delivered to Stormy Daniels in the way that it was, with the circumstances of concealment.
So, Jim, as we think about whether or not ultimately the jury is going to find Michael Cohen to be credible and trustworthy as it formulates its thought process on exactly whether Donald Trump should be acquitted or convicted of these crimes, would any further testimony from witnesses the defense calls ultimately matter, assuming one of them is not going to be Donald Trump? What does an FEC expert witness have to do with whether or not Michael Cohen told the truth?
It's not going to really affect the credibility of Michael Cohen, and there are a number of witnesses they might call whom they're not going to call. They're really the only person who can contradict Cohen is someone whom the jury won't believe either, and that's Donald Trump. And if he takes the stand, he'll be subjected to vigorous cross-examination. And he'll have to commit perjury to deny that he knew about the reimbursement of payment. He can be asked a series of questions that he really can't answer without incriminating himself, such as, you signed 9 checks, you're a micromanager, right? Right? And you sign checks unless you know what they're for? No, not usually. And did you see the invoices that related to those checks? No, I didn't. I show you the invoices. They say they were for legal services from Michael Cohen. What legal services did Cohen render to you? It was supposed to be pursuant to a retainer agreement. Where's the retainer agreement? And Trump can't answer those questions without incriminating himself. And so most lawyers would say it's an act of malpractice if they call him to the stand, because he'll just dig himself in much deeper.
You wrote a fascinating opinion piece in The Hill about this, Jim, in which you say that Donald Trump likely will not take the stand, but if he does not, as most people believe, there will always be the suspicion in people's minds about why he chose not to. Is this a real conversation, you think, inside his legal team right now?
Well, there are 2 courts that are considering the guilt or innocence of Donald Trump. One is the Court of Justice on Center Street in downtown Manhattan, and the other is the Court of Public Opinion. In the Court of Justice, the prosecution is not permitted to comment on the defendant's failure to take the stand. In fact, the judge can charge the jury that they draw no inference from his failure to take the stand, although judges frequently talk to defense counsel before they even give such a charge. The prosecutor can say that you heard the evidence presented by Michael Cohen. It's largely corroborated, and none of it is contradicted. And that will have a telling effect on the jury. In the Court of Public Opinion, the political court, it certainly ought to weigh strongly with voters who haven't already committed themselves that Donald Trump did not take the stand and never denied the charge that he made this secret payment of hush money to Stormy Daniels in order to influence the outcome of the 2016 election. That's the charge on which the jury will deliberate.
And of course, Jim, we also know, based on polling, including polling Bloomberg has done with Morning Consult in the past, that if he becomes a convicted felon, especially in swing states, voters may be less likely to vote for him. So it just does become a question of whether ultimately that conviction happens. How difficult is it going to be, in your mind, given all of the testimony that has been heard, the arguments have been made, for this to not end up, say, in a hung jury or even an acquittal?
Well, the jurors will be instructed that what they bring to the courtroom is not their biases, not their political leanings, not their attitudes as to whether they like or dislike Donald Trump, but their common sense. And if you look at the totality of these transactions, they were only accomplished for one purpose, and that was to benefit Donald Trump, to shut up Stormy Daniels on the run-up to the election, and to make sure she stayed silent until after the election was over, because the timing was such that it came on the heels of the Billy Bush tape, and Trump just couldn't take another sex scandal, according to his advisors in the Trump campaign. Now, the jury understands that, and in closing arguments, you can be sure the prosecutors will make them understand that. They're going to return a verdict of guilty after hearing the judge's instructions.
Huh. I wonder your thoughts on duration here, the extent to which jurors need time. I know that deliberations can take on a lot of different forms here. Jim, when this goes to the jury, how long will we wait?
Well, it's hard to say. I think if it's going to be an acquittal, they could come back within an hour. If they're mulling over the various 34 counts and mulling over the evidence and asking for the testimony of witnesses to be read back to them, or if they're asking for exhibits, it's more likely to lean toward a conviction. If it goes on too long, the judge may deliver to the jury the famous Allen charge. Allen was a case in the Supreme Court of the United States in 1896. And the Allen charge, which is sometimes called the dynamite charge, basically tells the minority jurors, without probing what the vote is at that point, that they have to follow their consciences and come to a conscientious conclusion individually, but they should take into account that the majority of the jurors believe something that's different from the conclusion they've reached, and consider whether they have to change their conclusion based not on the fact that the majority rules, but on the fact that the majority may have reasoning for their conviction that is persuasive.